CarIPI project, for those of you who don't know, it is a project funded by the 11th EDF, the European Development Fund, and it's being implemented since the end of 2019 and until mid 2023. It's the first project that focuses on the IP and innovation chapter of the EPA, of the Economic Partnership Agreement, that was signed in 2008 between CARIFORUM and the EU. And the project is there to support the CARIFORUM countries in reaping the benefits from this treaty in by, let's say, implementing the commitments and the specific provisions of the partnership agreement. The focuses that our project has is that the more harmonized the IP system functions worldwide, the easier it will be for our businesses to trade worldwide and to benefit from the opportunities that are offered by globalization. Counterfeiting is on the rise, to be that you find yourself being copied and products being sold maybe under your name. So it is maybe becoming more important to seek protection internationally. Today we'll talk about a few of the international treaties and systems that exist in the area of the different IP rights. And I give the word back to Mariana to call the first speaker.
Indeed, thanks Alexandra for showing us what CarIPI can actually do as regards IP treaties. Let's move then to Mr. Ernesto Rubio, who many of you have seen him already in one of our webinars. He's an external consultant, former WIPO Assistant Director General, and also previously advisor at the WIPO. Ernesto, please.
Thank you very much. I will be referring to the 3 international treaties that set up international systems for the recognition of trademarks, designs, and geographical indications. These are the Madrid, Hague, and Lisbon systems. The Madrid Protocol, specifically dealing with international registration of trademarks, the Hague Agreement on industrial designs, and the Lisbon Agreement on appellations of origin and geographical indications. So let me start with the Madrid Protocol, which we used to qualify it as a route to global branding. It is a brand protection system that is still in full expansion and is available today to nationals of 124 states. It is a business competitiveness tool of special interest to export industries, as we shall see. It's a balanced and flexible legal instrument, respectful of the sovereignty of each of its members. And it's a trademark protection route that is being increasingly used by all types of companies, and particularly attractive for small and medium-sized companies. So I will be focusing on these aspects of the Madrid Protocol. First of all, the fact of this being a brand protection system that is expanding and is available to nationals of 124 states. And I say this because the system is available only to nationals of its members, can only be used by persons who have an attachment to a contracting party. In principle, this is nationality, but this is also extended to persons who have a domicile or an industrial or commercial establishment in a contracting party. It is important that under the Madrid system, those who wish to use the system also need to have not only an attachment to a contracting party, but also a basic mark in that contracting party. And a basic mark means a trademark application or a trademark registration at the relevant office. The Madrid Protocol is in full expansion, we say, because it came into force in 1995 with only 5 members at that time. And today it has 108 members. We call them contracting parties, because they involve not only member states, 106 states, but also 2 intergovernmental organizations which qualify to be members of the system because they issue trademark rights valid in their territories of their member states. And these 2 intergovernmental organizations are the European Union with its 27 states, member states, and the African Intellectual Property Organization, which has at present 17 states. So the Madrid geographical coverage today is 108 members, covering the territories of 124 countries, and they represent 80% of world trade. Within the region, within the CARIFORUM region, we have 3 members, Antigua and Barbuda and Cuba, and who have been members for quite a number of years already, and Trinidad and Tobago, which joined very recently at the beginning of this year. We say this is a very attractive market for Caribbean exports because the Madrid Union members represent more than 80%, 84% of the export destinations of products exported by CARIFORUM countries. More than 84% go to Madrid Union members. And this is how those exports are represented at present. About half of them go to the United States and the European Union together. But there are other very important destinations of Caribbean exports. Switzerland, China, and Canada are very important destinations. Trinidad and Tobago is an important destination of exports from other Caribbean countries, but also India, UK, Mexico, Republic of Korea, Brazil, Japan, Colombia, Singapore, the Russian Federation, and many others. All of them are members of the Madrid Union. Only 15% of the exports of CARIFORUM countries go to countries outside that are not members of the Madrid Union, members here represented by this gray area. So it would make sense for those countries that are not yet party to the Madrid Protocol to join the treaty, because their nationals would then have the possibility to obtain easier trademark protection in those markets. We say it's a business competitiveness tool of special interest to export industries. And this is because the main objectives of the protocol are to facilitate brand protection in export markets and to lower the costs that the entrepreneurs have to pay to obtain and maintain such protection. And as a result, the protocol is helping entrepreneurs to export branded products and services, to add value to their exports and to improve their international competitiveness. And how does the protocol achieve those objectives? Well, by offering a simple, expedite, and cost-effective set of procedures for entrepreneurs to apply for the legal protection of their brands in export markets. And this is what we call the central filing of trademark applications, and to manage their trademark rights that are valid in various countries. And this is what we call the central management of trademark registrations. So to give you an example how this works, let us suppose that there is a Caribbean company wishing to get protection for its marks in these 12 markets represented here by their flags. In principle, it would have to go one by one to each of those countries or regions, to their competent authority, that is the trademark office in that country, and submit a separate application at that office. This will imply submitting different applications in different languages, and this would imply translation costs. It would imply fees paid in different local currencies with the corresponding currency exchange costs, and appointing local representatively, local representative that is frequently being required, and this would involve additional costs. And this person will have to follow different procedures from the very start with different time frames in each of the relevant offices. Let us see now how this compares with Madrid central filing, that is the possibility offered to nationals or residents in those countries that are bound by the Madrid Protocol. Suppose that this Caribbean company is a company from Trinidad and Tobago. It will be filing an international application at the TTIPO, which will check the content of that application, will send it to WIPO. WIPO will examine the application, will register it and publish it, and will transmit it to each of the designated contracting parties. So here you have a single application in a single language, English, fees paid in a single currency, Swiss francs. The local representative will only be required in limited cases, and a single international procedure from the very start up to registration by WIPO, and then strict deadlines for the procedure to be followed in front of each of the designated contracting parties. So this is really a great advantage, central filing. But central management is even more important, because suppose you have your right in all these countries already granted, your trademark right, but you will have to renew them every 10 years. And the way to renew them, if it is an international registration, is to ask just simply through one single request to WIPO, mostly electronically, and you ask for that renewal for additional 10 years, and WIPO will communicate it to each of the designated contracting parties. But suppose that a few years later you want to extend protection to some other members of the Madrid Union, to Japan, Singapore, and Antigua and Barbuda. Well, there's an interesting feature in the system that is called subsequent designation, whereby you ask WIPO to designate also these three countries, and WIPO will send the designation to these three countries, and they will decide if they grant protection for your trademark. And finally, during the life of your international registration, there are a number of changes that may take place. For example, a change of name or address of the holder or the representative, an assignment of rights, partial or total change in ownership. All these modifications can be recorded by WIPO directly with one single request, having effects in all the designated contracting parties of your interest. So really, it's a very important advantage as compared to traditional filing. We say the Madrid Protocol is a balanced and flexible legal instrument that is respectful of the sovereignty of each of its members. And this is because the legal framework of the protocol, of the Madrid system, is comprised of the Madrid Protocol as such, which was adopted in this diplomatic conference of 1989, the common regulations that are regularly updated by the Madrid Union Assembly, where all the members of the Madrid Union participate. This was latest updated in February of this year. Administrative instructions that are issued by the International Bureau, also in consultation with the members of the Madrid system. And finally, part of the legal framework of the Madrid system is also composed of the laws and the regulations of each Madrid Union member. It is on the basis of the laws and regulations of each member that each designated contracting party decides whether it corresponds or not to confer trademark protection to a given international registration for which they have been designated. No? And they do so in accordance with their own substantive trademark law provisions. Designated contracting parties may refuse protection within certain time limits, usually 12 months, but this time limit may be extended up to 18 months or even slightly more than 18 months in case of opposition by those countries that so request. The Madrid Protocol is a trademark protection route increasingly used by all types of companies, and particularly attractive for SMEs. Well, this is how the number of applications have been growing for the last number of years, almost 20 years, from 2002 onwards. And we see that they have been growing almost constantly, with the only exception of the economic crisis of 2008, 2009, and most recently of the pandemic crisis of 2020. The Madrid Protocol is being used by a variety of industry sectors. About half of the registrations filed, or the applications filed for protection trademark protection correspond to areas of the research and technology sector, health, agriculture, and business sectors, basically. And it is a cost-effective protection system. And we say so because out of the 64,000 international applications that were filed in 2020, on average, each of them designated some 7 countries for protection. And they designated some 2 to 3 classes, goods in 2 or 3 classes for protection. And the average fee paid per registration was 3,392. Relatively less expensive if you compare to what at present would cost to obtain protection for a trademark in 7 different countries or 7 different territories. And even 50% of the registrations that were registered last year paid less than 2,400 Swiss francs. We say it's particularly useful for small and medium-sized companies because most of the users of the system were small and medium-sized companies. In 2020, for example, some 211,000 holders of Madrid registrations who represented 80% of the right holders were owners of only 1 or 2 international registrations, as you can see here on the left-hand side. Obviously, there were some 36 big multinationals owing each of them more than 500 trademarks under the Madrid system, but the major number of users of the system, as you see, are holders of just 1 or 2 international registrations. Now let us move briefly to the Hague system on industrial designs. Industrial designs that, as you know, protect the outward appearance of a product or part of it. The Hague system, also administered by WIPO, aims at facilitating the protection of industrial designs in up to 75 contracting parties. And they involve not only states, but also intergovernmental organizations through a single international application that results in a single international registration with individual effects in each contracting party that has been designated therein. The Hague system is governed by 2 autonomous and independent treaties. The Hague Act of the Hague Agreement of 1960, which has at present 34 members, and the members to this act are only states, and the Geneva Act of the Hague Agreement that was adopted in 1999 and has at present 66 members. And in the case of the Geneva Act, these members are both states and certain intergovernmental organizations. This is how the Hague system has expanded since it came the Geneva Act came into operation in 2003. And as you see, the Geneva Act has been increasing the number of its members. Many members of the 1960 Act have been joining the 1999 Act or Geneva Act. This is how all the members of the Hague Agreement are grouped according to the most recent act applicable to them. And you see that the Geneva Act has 66 contracting parties, as I said, 2 of them intergovernmental organizations, the African Intellectual Property Organization and the European Union, and 2 countries in the CARIFORUM region, Belize and Suriname, being members of this Act, 1999 Act. These 2 countries, Belize and Suriname, are also members of the 1960 Act. Under the 1960 Act, there are still 9 member states that have not yet joined the 1999 Act, the Geneva Act, but most of them can also be covered either because they belong to the African Intellectual Property Organization or to the European Union. They may also be covered by the extensions of protection requested under the Geneva Act. The only country that cannot be achieved or through, in which protection cannot be achieved through the Geneva Act at present is Morocco. But we expect that soon Morocco will also join, and all the countries in the system may be achieved through the Geneva Act. So this is the current coverage, 75 members and 92 countries covered under the Geneva Act in July 2021. How does the Hague system work? Well, The Hague system can be used by anyone who has an attachment to a contracting party, and in this case, attachment may be not only industrial or commercial establishment or nationality or domicile, but also habitual residence. And unlike Madrid, the applicant here does not need to have a basic design in that contracting party. And moreover, he may designate its own contracting party for protection. So suppose that you're a designer or a company from Belize, which is a member of both acts, the Geneva Act and the Hague Act, and you want to get protection in these 12 markets, including Belize as such. You file an international application at the World Intellectual Property Organization, and you can do it electronically, and the WIPO, if it accepts your international application, it registers your right, and the design is communicated to each of the designated contracting parties, who will decide whether they accept it within certain time limits. So you have, again, here, like in Madrid, a single application, a single language. In this case, it can be English, French, or Spanish. Fees paid in a single currency, Swiss francs, local representative only required in limited cases, and a single international procedure up to registration by WIPO, and then strict deadlines in each designated contracting parties. The application for the protection of your industrial design can contain up to 100 designs, the reproductions or specimens indicating the product in one locale or class for which to get protection. And some countries do require the applicant to identify the identity of the creator. The application can be filed at WIPO using the electronic filing interface. And to give you an idea of costs, if you consider one international application for one design, one reproduction designating 5 contracting parties, that is Belize, Suriname, European Union, United Kingdom, and Switzerland for protection in 31 countries, you would be paying a total of 667 Swiss francs for a 5-year protection. And if you were to ask for extending protection also to Canada and to the United States, the total cost involving these 33 countries would be less than 2,000 Swiss francs. So you see, it's a relatively not expensive system to get protection for your designs internationally. Again, in the case of the Hague system, as in the case of the Madrid Protocol, each designated contracting party decides whether it corresponds or not to confer industrial design protection to a given international registration in accordance with its own substantive industrial law provisions. And the designated contracting party has to do so within strict time limits, which may be 6 months or 12 months from publication of the design in the International Designs Bulletin. The effects of the international registration in all those designated contracting parties that have not received protection within those time limits are the same effects as a registration of a duration of 5 years recorded by the office of that contracting party. And in principle, this registration is renewable for additional periods of 5 years. And the renewal can be, again, done directly with a simple request to WIPO, which will notify to each of the designated contracting parties. And there are a number of changes also that can be recorded by the International Bureau with effect in all those designated contracting parties. The duration of protection under the 1999 Act will be minimum 15 years, but it may be longer depending on the legislation of each designated contracting parties. So there are some designated contracting parties that have a grant protection for up to 20 years, or 25 or 50. That is the vast majority of members of the Hague Union at present grant protection for 25 years. Now let us move on to appellations of origin and geographical indications. As you may know already, geographical indication is a sign, not necessarily a denomination, used on products of a specific geographic origin, the qualities, reputation, or characteristics of which are essentially attributable to that place. And an appellation of origin is a special type of geographical indication. It always has to be a geographical denomination, not any type of sign, but a geographical denomination of a country, region, or locality. It serves to designate a product originating therein. In this respect, it's as any other GI. And the quality of characteristics of which are due exclusively or essentially to the geographic environment, including natural factors and human factors. Natural factors may be soil and climate, human factors, for example, method of production or manufacture. So in the case of appellations of origin, you have a stronger qualitative connection between the product and the place of origin. How do you get protection for appellations of origin and geographical indications? Well, nationally, there are countries that do have, many countries do have sui generis regimes, either through a special statute or through registration as an appellation of origin or a geographical indication. And some other countries only grant protection to GIs through collective or certification marks. And to get protection abroad, usually the traditional way was through bilateral agreements whereby two countries granted themselves mutual recognition of certain GIs. But also there are many countries that allow for the registration of foreign GIs as appellations of origin or GIs or collective or certification marks. And then there is the international registration system, which is called the Lisbon system, administered by WIPO, and which I will be referring now. The Lisbon system is governed also by two autonomous independent treaties, like the case of Hague. In this case, it's the Lisbon Agreement of 1958, the original agreement, revised in Stockholm in 1967. And more recently, the Geneva Act of the Lisbon Agreement, which was adopted in 2015 and came into force only last year. The Lisbon Agreement, the original one, only granted protection or referred to the international protection of appellations of origin, not for any type of GI, but really appellations of origin. And it has at present 30 members, and all of them are member states. The Geneva Act of the Lisbon Agreement is more flexible, and it was adopted specifically with the intention of extending the system also not only to appellations of origin, but also to the international protection of geographical indications more broadly. And at present, it has 9 contracting parties, including the European Union, and it extends its effects to the territories of 33 countries. Any country may be a party to both treaties. So the members of the Lisbon Union today, these are the 9 contracting parties of the Geneva Act 2015, and these are the 30 member states of the Lisbon Agreement, Original Act, and Act of 1967. Here you can see that within the CARIFORUM region, there are 3 countries, Cuba, Dominican Republic, and Haiti, that are members of the original Lisbon Agreement. The Lisbon Agreement, the Lisbon system as such today, therefore, extends its coverage to 54 countries. If we take together both the members of the original Lisbon Act and of the Geneva Act. So this is the current coverage of the Lisbon system, 54 countries, mostly in Europe, 33 of them, in Asia and the Pacific, 8, in Latin America and the Caribbean, 7, including the 3 that I mentioned, part of the CARIFORUM, and in Africa, 6 countries. How does it work? Well, suppose that there is an appellation of origin protected as such in the Dominican Republic. The competent authority in the Dominican Republic files an international application in English, French, or Spanish with WIPO. It indicates in that application the product area of production and legal basis for the protection of that appellation of origin in the Dominican Republic. It pays 1,000 Swiss francs, and WIPO registers the appellation of origin and notifies the registration to all the members of the in this case, of the Lisbon Agreement. So in this case, you're not choosing where you want to get protection. In principle, your protection is requested in all the members of the system. And the international registration will get protection in those countries, provided that they do not refuse them within a period of 1 year. The refusal of protection must specify the grounds, for example, because in a given country that identification of an appellation of origin, well, it's considered a genetic character of the denomination, or because it is in conflict with an earlier right. But if it is recognized, the content of protection will be against any usurpation or imitation of the appellation of origin, even if the true origin of the product is stated, or if it is used in translated form, or if it is used accompanied by terms such as kind, type, make, imitation, and the like. And the term of protection principle is indefinite as long as the appellation of origin is protected in the country of origin. The Geneva Act is more flexible. It allows flexible means of protection because a contracting party under the Geneva Act may ensure protection through any type of legislation. It may ensure it through generis law, but also through trademark law or administrative provisions or other legal means, provided that they meet the requirements of protection of the Geneva Act. Third parties are also clearly protected under the Geneva Act because whoever can be affected can request the national competent authority to notify a refusal of protection based, for example, on prior trademark rights or genetic character of the appellation of a geographical indication. And the Lisbon the Agreement Geneva Act also has some additional flexibilities. Contracting parties may declare their intention to request the payment of an individual fee or a declaration of intention to use the appellation of origin or geographical indication. So here I conclude the presentation or the introduction of these three systems, but I would like, before concluding, ask ourselves these questions. Are these treaties of interest to the Caribbean countries? And to start with, regarding trademarks, do we think that there are many Caribbean companies wishing to protect their trademarks abroad? Well, I did some research and found out in the WIPO statistics database that there are quite a number of Caribbean companies that file for protection of trademarks abroad. In fact, during the period 2010-2019, 10-year period, 28,000 applications were filed abroad by Caribbean companies. And the origins were mostly Bahamas, Barbados, Belize, Dominican Republic, Cuba, Jamaica, St. Lucia, Trinidad and Tobago were those that were filing companies whose companies were filing the largest number of applications. But we see that all the Caribbean countries, to some extent, sought protection abroad. And where were those trademarks seeking protection? Well, again, these were mainly in Madrid Union states or contracting parties. The most designated contracting party, or the main destination of trademarks filed abroad was the United States of America, but also the European Union accounted for a large number, Russian Federation, China, Mexico, Canada, Brazil. Out of all of them, that is, out of 20 major destinations, 16 were Madrid Union members. So I would say really Caribbean companies would benefit from being members of the Madrid system. These are some trademarks having seek protection via the Madrid system from Cuba. And these are trademarks mainly for tobacco, for rum, as you may see, but also for tourism and aviation services, for pharmaceutical products and vaccines, such as Soberana here. These are some examples also of trademarks from Antigua and Barbuda, the other country that has been a member of the Madrid system for some time already. For products, eye care products, for example, and most recently the ACB Caribbean for banking and financial services. But then looking at this Madrid monitor, I found 335 Madrid active trademarks by holders from other Caribbean countries. And interesting enough, for example, some relatively well-known, such as Beliquin beer from Belize, or the Ron Bermudez from Dominican Republic, or the Pavo beer from Suriname, or the El Dorado for rum from Guyana. And all these are trademarks that are protected under the Madrid system, but their holders could not ask for protection from their countries of origin. They had to file their applications through another country, through a Madrid Union member. Why not give them the opportunity to file the application from their own home countries? And regarding Caribbean designs, I also had a look at to find out whether there were many Caribbean design creators wishing to protect their designs abroad. And in the global design database of WIPO, I found quite a number of designs protected abroad. For example, for flasks and containers from Antigua and Barbuda, and from Cuba and from Dominica, for a steel pan magnet from Trinidad and Tobago, for footwear inserts from Bahamas, for laboratory test tools from Cuba, or for advertising devices like here from the Dominican Republic. But these Caribbean designs, they had asked for protection abroad, having to file their applications directly abroad. Why not via the Hague system, which would have made things much easier and less expensive for the designers? And finally, regarding Caribbean geographical indications, we may ask ourselves, are Caribbean producers interested in getting GI protection for their products internationally? And again, I would say yes. There are some examples already. For example, in the United States, there's the Jamaica Blue Mountain Coffee protected as a certification mark, both the denomination as such, but also the logo represented here. And in the European Union, there's a possibility to get protection for designations of origin or geographical indications. And the Café de Valdesia from Dominican Republic was the first, in fact, CARIFORUM registration, for the moment the only one, registered as a PDO. It protected the designation of origin in the European Union. But there are 3 pending registrations as protected geographical indications for Trinidad Montserrat Hills Cocoa from Trinidad and Tobago, for Demerara rum from Guyana, and for Cuba for rum from Cuba. Cuba has clearly a long experience in the protection of appellations of origin for tobacco, for rums, for coffee, for mud, for mineral water. All these are appellations of origin protected in Cuba for these type of products. 20 of them have been protected abroad under the Lisbon system, all those for tobacco and rum, for example. The Dominican Republic also has a very extensive experience in the protection of appellations of origin and GIs, and through collective and certification marks as well, for coffee, for cocoa, rum, cigars, petrified wood, avocados, mangoes, grapes, special stones. For example, all these are appellations of origin that are protected in the Dominican Republic and that could get protection under the Lisbon agreement abroad. And these are GIs. These are GIs protected as such as GIs in the Dominican Republic, and these others are protected as certification marks or collective marks. In order to be able to protect these that are protected in the Dominican Republic as GIs or certification marks, this could be done if the Dominican Republic were to become a member of the of the Geneva Act of the Lisbon Agreement. There are other Caribbean geographical indications that we can find. In Guyana, for example, the Demerara rum, sugar, and molasses. In Jamaica, the one that I mentioned already, Jamaica Blue Mountain Coffee, the Jamaican jerk, Jamaica rum, and in Trinidad and Tobago, the Montserrat Hills PGIs. And in other countries, at least countries, some indications that, or some products that could enjoy protection as geographical indications, like the black pineapple from Antigua and Barbuda, the cascarillas from Bahamas, or the Cujon oil from Belize, or the rum from Barbados, or nutmeg from Grenada, sarsaparilla from St. Kitts and Nevis. So I would say it would be interesting to get protection for all these types of geographical indications that can be found in the Caribbean region by becoming a member of the Lisbon system. And my recommendation in the case of the Lisbon system would be to become a member of both the original Lisbon Act and also of the Geneva Act. So to extend protection up to the territories of 54 countries. So to conclude, can CarIPI cooperate with CARIFORUM countries interested in taking advantage of these treaties? Well, as Alexandra already mentioned, CarIPI is ready to work jointly with interested countries in identifying the requirements and preparatory work needed to join these treaties, making studies in this respect, offering pre and post-accession training to staff involved in operations, promoting the use of these systems by national producers, design creators, and entrepreneurs through awareness raising and capacity building events, and through tailor-made promotional materials. So here I conclude my presentation. I thank you very much for your attention.
Brief clarification. I might just say that regarding the Lisbon Agreement for the protection of geographical indications, of course, right now, the fastest way for protection would be to conclude the agreement that is being negotiated bilaterally between the EU and the CARIFORUM countries. And thereby there is a list, a short list of geographical indications now that will obtain protection in the EU. But still the Lisbon system can be interesting beyond the EU specifically.
Thanks for this clarification.
Okay, I think we can move on.
We can move on, yes. There's no questions for now. Please keep them for later if you are thinking of any. Now we welcome our WIPO speakers, Mr. Martha Friedley, a legal counselor in the Department for Trademarks, Industrial Designs, and GIs, who will present the Singapore Treaty on the Law of Trademarks.
Thank you to CarIPI for this invitation. I'm really happy to be here and to share with you some notions about the Singapore Treaty. Let me just try and share my screen. All right, so the Singapore Treaty on the Law of Trademarks is one that was, and I think I skipped one, so let me go to the previous. It was a treaty adopted in 2006. It's one of the several WIPO administered treaties. It was adopted at a big conference in Singapore. And not only 117 member states participated, but also 3 intergovernmental organizations that have an office with competence to register trademarks with effect in the covered territories. We also had several observer organizations participating, normally those that have interest in the registration of trademarks. Our most recent member is Uruguay. The Singapore Treaty entered into force on March 16, 2009. Upon entry into force of the Instrument of Accession by Australia. Currently, there are 51 states party to the Singapore Treaty, and you can consult the list of contracting parties in that link that I included in my slide. The Singapore Treaty is not an international registration treaty, although it can be a facilitating factor for those countries that do enter those international systems. It isn't and a totally new treaty. It is the revision of an existing treaty, the Trademark Law Treaty 1994. And it took a while to negotiate this treaty. Ernesto Rubio was involved in that negotiation, and he will remember how we spent several sessions of the SCT trying to draft and conclude this instrument. Now I'll tell you what the Singapore Treaty is and what it isn't. I already said it is not an international registration system. It is not comparable to the Madrid system. What it does is it tries to harmonize and simplify formalities, and it only refers to formalities. It does not deal with examination, for example. Formalities applied by national offices to trademark registration procedures. So how do we do that? Through harmonization, the idea is to deal with the application and then with the post-registration actions, all those changes that happen during the very long life of a treaty, because you get protection for 10 years, but eventually you could renew that protection for several periods of 10 years. So it's a very long life of a trademark registration. And that is not necessarily a formalities provision. That and the next one, the application of the Paris Convention to service marks, are some of the few substantive provisions in the Singapore Treaty. The Singapore Treaty is also about simplification of procedures. And as Alexandra was saying earlier on, this is very important, especially for the international protection of brands. It is important to have similar requirements and to have those procedures expedited. So the Singapore Treaty and the TLT 1994 deal with, for example, the requirements to establish and acquire filing date. One of the most important things is to have your filing date so that can determine your priority and your international priority. The possibility to also have in one single application a number of classes, a number of products and services in different classes of the NIS classification. Another very important feature of the TLT and of the Singapore Treaty is to eliminate legalization, notarization, or certification of signature. But of course, there are some exceptions that allow the applicants to still file notarized or certified documents. And generally, there's no need to file an extract from the Register of Commerce, except, as we know, in some cases where this can be required. With regard to filing date requirements, then, these are at the top the indications that are necessary according to Article 4 of the TLT and the Singapore Treaty. And if it is applicable, like if your system is one of those that is use-based, then you can require a declaration of intent to use or virtual use of the mark. And you can also require fees if you had that requirement prior to joining the treaty. As to multi-class application and registration, there is, of course, a possibility to have a longer list of goods and services. However, the offices joining, the countries joining the Singapore Treaty will not lose the possibility to charge per class. So they would have no problem in keeping their current fee structure. And there is a possibility under the Singapore Treaty to make a reservation with regard to multi-class applications. And it is to have a separate list of goods and another list of services. So say, for example, if this was your international, if this was your application, you would have this mark. And if your country had made that reservation, then you would have to separate your list of goods and services and have one application for the goods and another application for the services. This is the sense of the reservation. Obviously here I have put the absolute exaggeration of what a legalized and certified document would look like. Normally it doesn't look as bad, but having a terribly legalized or certified document does not provide you additional legal security, and that's why it was considered already in the TLT 1994 that this was not a desirable requirement as long as the document is signed. There are exceptions to that rule, and obviously these are important. The change in ownership, if the change results from a contract, you can have the copy of the contract, the copy of the extract of the contract certified. If there's a change resulting from a merger, you can have that copy of that merger document certified. Or if your change results from a court decision, you can also have the corresponding document, usually a legal decision, certified. And the other biggest exception is if prior to joining the TLT or the STLT, you are a member of this apostille convention, which is actually called the Convention for Abolishing the Requirement of Legalization. Although the apostille is one legalization with one chancellery in one country and then with another country. And it eliminates all the other certifications in between. So the general structure of all these provisions, so from Article 3 to 5, from 10 to 13, from 17 to 18, they all have this structure. So to harmonize and simplify, there are maximum lists of requirements for each of these articles. Then there's a prohibition of additional requirements, but the office reserves the right to require evidence in case of doubt. And that is the balancing provision to the previous one. So these are basically the provisions of the TLT and the Singapore Treaty, except that Singapore has the licensing provisions. So for all of these, the same structure is applied. You will see there that this is about the whole application and post-registration procedure. Now, there are other articles in the Singapore Treaty that are the final and administrative clauses. These are not trademark related. They deal with treaty law. Normally for those that have done some international law, this is basically Vienna Convention on the Law of Treaties. And they appear in most every treaty, whether it is an IP treaty or not. And there are, of course, provisions or declarations that contracting parties to treaties, not only WIPO treaties, but any treaty, can make upon accession or ratification. And the reservations have the effect of limiting the application of the treaty with regard to what is being reserved. Like in this case, the Singapore Treaty has few permitted reservations. Some of them are like this one, special kinds of marks, the multiple class that I mentioned before. So you can divide your multiple class application. And this was very much pushed by OAPI, the African Intellectual Property Organization, because they have a system whereby they cannot mix the list of products and the list of services, even though they can have multi-class. Japan had pushed a lot to keep this reservation that was possible according to the TLT 1994, which is the possibility of having substantive examination on the occasion of renewal. And with regard to the articles on licensing, a provision regarding certain rights of the licensee, that the licensee will not be required to be recorded in order to join proceedings and claim damages for infringement. With regard to special kinds of marks, these are the types of marks, and I have included here an example from New Zealand. These associated derivative marks in other countries, I think they have other names. If I'm not mistaken, in the EU, they are called series of marks or family of marks. They are not statutory categories. They cannot be transferred separately. Like say, for example, here the dominant element is Florina, but it applies to mango chutney, tomato relish, or piccalilli. So the thing here is, for these special kinds of marks, you would not apply the provisions of the Singapore Treaty if you make that reservation. With regard to defensive marks, these marks exist in some countries. I think it dates back to the times prior to the TRIPS agreement, when the protection of well-known marks was not so developed. And the idea is to protect the same mark for goods and services in different classes of the NIS classification. And so for these provisions, for these defensive marks, families of marks, etc., the STLT provisions on application, filing date, provision of application, use of model international forms, change of ownership, these provisions would not apply to those types of marks. Now, who has reserved what? With regard to the reservation on certain rights of the licensee, OAPI has entered that reservation, Bulgaria, Spain, and Uruguay. With regard to the reservation on having a multi-class list of goods separate from the multi-class list of services, is OAPI. Actually, they pushed for this reservation in the Singapore Treaty. With regard to special kinds of marks, Japan. But Japan did not push when they joined the Singapore Treaty for the reservation with regard to re-examination of service marks. By then, I think the law had changed and they did not need to avail themselves of that reservation. As we know, the reservations can only be entered when depositing the instrument of accession or ratification. So how does it look for TLT and STLT in Latin America and the Caribbean? Well, the Trademark Law Treaty has basically been widely supported in Central America and the Caribbean, some also in South America, and some countries have made already the transition from TLT to the STLT. But one interesting country is Uruguay, because Uruguay was not a member of the TLT. However, it was a signatory of the Singapore Treaty and has ratified towards the end of last year. Now, what are the benefits of acceding to these formalities treaties? I could tell you a lot of good things about the TLT and STLT, especially the STLT, because I participated very actively in the diplomatic conference, but I chose to bring you some evidence from the chief economist of WIPO. In 2012, the chief economist of WIPO conducted an inquiry on these so-called formalities treaties. So he studied not only two trademark treaties, the TLT and the STLT, but also the PLT, which is the equivalent in patents. So an inquiry was sent to all offices, but as usual, we received less responses than questions we sent. And there were 52 offices responding, 25 were high income, 28 were middle, low income. And some of the results were that the TLT is the most widely adopted treaty and very well received in low and middle income countries. What is the timeline that it takes to implement the TLT and the STLT? It goes anytime from being ready already prior to deposit of the instrument of ratification, so 0 months because people did the work before, to 4 years. So it's very variable how long it takes to implement. And for some countries, the full treaty implementation may require primary legislation to be enacted. So this is more or less the support that countries thought they needed. So many countries thought they did not need any support. They were ready to immediately apply the SDLT. However, some of them thought that they needed some awareness raising support, IT support, legal advice, and training. So that's how it looked at the time when the senior economists conducted that study. So what are the benefits? So basically, all these treaties, TLT, SDLT, and PLT, have brought benefits for users. Remember, we're talking about even national registrations, but having the same set of requirements in different countries does help. Even if you have an extended and direct portfolio of trademark applications, simplifying procedures is very good. So in middle and low income countries, it took amazingly less time to implement the treaties than it took in higher income countries. There was also this very important thing down here, and I'm glad to hear that EU, EPA, and CARIPI are ready to help with legal advice and customized materials, and also specific training for operations people. I think that is fantastic. However, WIPO is also ready. I think our normal line of activity is legislative advice rather than operations training. The Singapore Treaty did something that the TLT did not have, and it was to build an assembly. The assembly of the Singapore Treaty is something that the drafters of the TLT could not conclude at the time. And this assembly was put to work, and in 2011, it already adopted the methods of representation of non-traditional marks for all these marks that you see on the screen. And that is my last slide. I think I wasn't too long. The Singapore Treaty is quite a detailed treaty. Thank you, and I'm like the previous speaker, I'll be there for questions if they're any.
Now we move on. We would like to invite Mr. Leontino Taveira, who's Head of Technical Affairs and Regional Development at EU POF, who will go through this treaty in particular. Please, Leontino, you have the floor.
Thank you, and greetings from Geneva. I hope all is well for you to be seeing the screen I'm sharing, my PowerPoint. So I'm here to present to you a harmonized system. It is not a registration system in itself because registration is conducted by the individual UPOV members, such as the European Union covering very many states, or Trinidad and Tobago covering its own jurisdiction at a time. But quickly, what I'm going to speak to you is the limiting factor in any business strategy for particularly those products where Caribbean countries are very strong. We've heard today about products derived from tobacco, from sugarcane, and we could list a number of products that are produced in the region and that have a great market potential. So what I'm about to present to you is plant variety protection as a means to promote plant breeding and resolve and address a limiting factor in agricultural development. Because what farmers face currently are more challenging conditions for growing their crops, as well as farmers must do more with less. They've got to produce more in less area using less inputs. And this is not a challenge farmers can address by themselves. They require the best means to transfer technology, which is new, improved varieties. This is why UPOV's work is focused.
I'm attending. I thought there would be some.
This is why.
Go ahead, yes.
Thank you. Yes, I hope we can trigger lots of discussion. I'm looking forward to that in the end. But I just wanted to recall the role of UPOV, which is to provide a system that is conducive to the development of new varieties of plants. And we do that through a plant variety protection system, therefore granting plant breeders' rights to those farmers, cooperatives, any individual that develop a new plant variety. How does it work? Well, here you have the typical chain of transfer of technology from plant breeders, generally described as plant breeders. They could be individuals, they could be farmers, they could be private, public companies, small, medium-sized enterprises. They develop new varieties that reach farmers, that reach consumers. But in order to maintain this flow of improved varieties reaching farmers and consumers, there's got to be a means of controlling the use of these varieties. There's got to be a return to the investments in plant breeding, which is an investment that requires or many decades to mature. Looking for information on how's the situation in the Caribbean, we can find literature on the internet, such as this one here from the FAO, where the exports compared to the imports in the Caribbean region are described with an upward trend in the total import value of agricultural products, whereas the exports in a stable trend. The data is slightly outdated. I hope the situation has improved favorably to the region, of course, but I'm only bringing this information here to raise your attention to the potential there is in the region. If we look for other sources of information available also on the internet, we can come across the Caribbean Agribusiness Organization. There's a review of opportunities for investment in the region, where we see a call for further investments in citrus production, in papaya production, and here clearly highlighting that the demand remains undersupplied, but also for golden apple. For those colleagues here on this side of the Atlantic, golden apple is a delicious fruit that grows abundantly in the Caribbean region, high value for buyers, high value for export, but who's developing new varieties to increase productivity, to increase availability of this product? Bananas is here. We have another opportunity. Bananas is a crop that faces severe disease pressure, and new varieties are necessary to fight against these new diseases. I could relate somehow to a current pandemic we are facing for humans. Well, for bananas globally, the black sigatoka disease has been causing pretty much the same effect as we're facing today with the COVID situation. So here my questioning to you all, just to set you thinking, who is providing new varieties, the best means to transfer technology to farmers and growers? Who's developing these new varieties? Where is the flow of innovation coming from? One or very few, or is there an environment that is conducive to further investments and greater diversifying the range of providers of technology for farmers in the region? And this is the benefit of the UPOV Convention, because where there's UPOV membership, it is demonstrated, as I will demonstrate for you in a moment, there's more investment in plant breeding in general. For example, in Australia, once Australia became a member to the 1991 Act of the UPOV Convention, the private investment in new varieties of wheat has more than doubled in a time span of around 10 years, therefore enabling the government to divert investments into other priority areas, leaving the private sector to bring in new monies as to invest in the development of solutions for farmers in that country. Another benefit of UPOV membership is starting with services provided by the union. UPOV offers an online application system, so members do not have to develop their own national online application system. UPOV already provides that free of charge for their members. Databases, other software, training and assistance opportunities for different stakeholders is also included along the package of benefits from UPOV membership. Cooperation amongst UPOV members is also and possibly the greatest benefit of UPOV membership. You don't have to take my word for this affirmation. I'm just going to quote another plant variety protection office from Switzerland. Well, many of you may be familiar with the Swiss approach for quality products and services. Needless to mention, Swiss products that are of high quality and consumed worldwide. Well, Switzerland is a member to the UPOV Convention, and they have recently provided a presentation in one of our events about a couple of months ago, where they explained the rationale for their operation under the UPOV Convention. So the idea is to allocate one staff part-time with very little budget, without performing directly any testing. Nonetheless, they offer plant variety protection for all genera and species. How do they do that? They cooperate with other UPOV members. They exchange test reports, they commission testing at other members' facilities, and they take over existing test reports from other UPOV members, therefore enabling their office to run pretty much with one staff working part-time. What does UPOV do to support this approach in organizing such low-cost system? Well, UPOV enables the cooperation through allowing, here on our website, we have a number of forms that can be filled out to request cooperation, to request test reports. So you just have to take one of these standard forms from our website, look up for the crop you are interested at, and apply or request the results from other UPOV member. As simple as that, you can obtain the necessary information for taking your sovereign decision on whether or not to grant plant variety protection for particular applications. If you would like to become a UPOV member, there first must be a decision, a policy decision as to understanding the benefits of UPOV membership, the importance of plant breeding in transfer of technology in agricultural development. Once this policy decision has been taken, please contact the Office of the Union. We'll work with you for developing a legislation that is in conformity with the UPOV Convention, therefore providing the basis for international harmonization. Once this legislation has been enacted and is in force, your countries may deposit their instruments of accession to the UPOV Convention. Maybe I should leave it at that. This is just a teaser. Agriculture is very important for all countries in the region, and I remain available in case you would wish to further discuss possibilities in terms of developing legislation and promoting agricultural development through the use of plant variety protection. Thank you very much for the opportunity, and I'm looking forward for your questions. Thank you.
We will move forward now with the experience of the Hague membership, presented by Corinne Flowers, Deputy Registrar at the Belize Intellectual Property Office.
I must first introduce our relevant law, which is the Industrial Designs Act, Chapter 254, with Revised Edition 2011. And it says that the definition of an industrial designs comprise of any composition of lines or colors or any three-dimensional form or any material, whether or not associated with lines or colors, which gives a special appearance to a product or industry or handicraft and can serve as a pattern for a product of industry or handicraft and appeals to and is judged by the eye. provided that it does not consist of anything which serves to obtain a technical result and leaves no freedom as regards arbitrary features of appearance. In other words, it has to do with the appeal to the eye, and it does not have to do with the functionality of the product. Next slide. It must be new. The commercial exploitation must not be contrary to public order or morality. Next. So in examining, we'll check the forms that they are complete and that the necessary documents are attached, such as the drawings, the photographs, or other adequate graphic representation of the design. You must have an indication of the kind of product for which the design is applied for using the Locarno classification, which is used for the purpose of the registration of industrial designs. Next, if the application is in respect of 2 or more designs, the designs must fall under the same class of international classification or to the same set or composition of articles. What that means is, example for jewelry. I think jewelry is under class 11-01. Now, other articles that come under jewelry would be chains, earrings, rings, etc. So it can have 2 or more, or as we heard earlier in international application, you can have up to 100 articles under one application. It must consist of a statement from the creator of the applicant if the applicant is not the creator. If the applicant is claiming priority, the application must contain a declaration of priority. Next slide. It must comply with the definition of a design under the Act. The prescribed application fee must be accompanied with the application, and the industrial design must not be contrary to public order or morality. Next slide. There is no grounds in our Act to refuse an application once the registrar determines that it has met all the requirements. Once that is determined, the notice of the acceptable application is published once online in our intellectual property journal, and thereafter we issue the certificate of registration. Next slide. The duration of the protection for us here is 5 years from the date of filing of the application for registration, but it can be renewed for 2 further consecutive periods of 5 years. Next. Invalidation of registration of registered design, the application for invalidation must be made to the court. That is where, for example, we said it must be new. However, when we are checking or examining the design, we do not look for that to see that it's new for us to proceed. If we proceed and somebody is not in favor of it, for example, they are saying that the grounds for invalidation is that the design is not new, then that goes to our court. The applicant for registration is not the owner or his successor in title, grounds for invalidation, or the application was made with the intention of defrauding the owner, or any other ground on which the registrar could have refused to register the design, goes to the court. The registrar of the Supreme Court will notify the registrar of the Intellectual Property Office of the decision of the court to invalidate a design, and the registrar will publish a reference of the court decision to invalidate in the journal as soon as possible. Next slide. Appeals. Any person who has been aggrieved by a decision of the registrar under the Act may within 2 months of that decision appeal to the court. Next slide, application of treaties. The provisions of any international treaty in respect of industrial property, to which Belize's party shall apply to this act, and matters dealt with herein, and where there is any conflict, the provisions of the treaty shall prevail. Next slide, the treaties. So the Hague system, which we are part of, comprised of the Hague Act 1916, came into force for us in July 2003, and we are also a party to the Geneva Act that came into force for us here in February 2019. It's a simplified process, the Hague system, for the protection of design in multiple jurisdictions. It is also a simplified process for the subsequent management of international registrations. Simplified process because the applications are all handled through a single office, the International Bureau at WIPO, and all future amendments to the registrations and renewals are the responsibility of that single office, the International Bureau at WIPO. The advantage is it eases the applicant of the burden of having to apply to multiple IP offices and to deal with different formalities in respect to applications for registration, amendments, renewals, and recordals such as change of name, change of address, etc. in different languages, and paying varying fees that would involve purchasing several currency denominations. We heard that earlier from Mr. Rubio. So our experience here at the office is that it's not a burden. We are not burdened with the task of having to do formal examination, as well as data entry, publication, the preparation and issuance of a registration certificate, since these are all the responsibility of the International Bureau. We're designated office and the International Bureau takes care of all this. And the payment of our fees, we get our fees paid into the government of Belize account monthly, on a monthly basis. Most of our applications, as I show in the statistics, are from international designations to us. We don't have much national applications. We would have like an average of about 5 national applications for the year. So if you can see from 2015, we have 212 applications through the IB, registrations, renewals. And 2019, we had 103 applications, 87 registrations, 243 renewals. Last year, we had 82 applications, 80 registrations, 257 renewals. So that has been our experience. We know we need to create awareness to our local applicants. They have asked, we have told them, but they don't seem to be quite interested, the ones that come. But we need to create awareness for them because it's so important. It's to their advantage to get on the market, get out into the international arena quickly, to showcase their products, you know, for others to see, you know, they can get connections early. So we have to embark on an awareness campaign for our local applicants. Thank you very much.
Thank you, Ms. Flowers. Many thanks for sharing the experience of Belize with the Hague Agreement and for pointing out the need for raising awareness. It's now time to move on with TTIPO, the Office of Trinidad and Tobago. They will share the Madrid and STLT accession journey. I will give the floor now to Ms. Steffi Mohammed, Trademark System Specialist at TTIPO. Steffi, please.
Thank you, Mariana. Good afternoon and good morning to all. Just give me 1 second, let me share my screen. Yeah, everyone can see it? Okay, great, thank you. So I will definitely try to be as quick as possible and not be too long. So don't let the overview scare you. It looks very long, but it is not going to be that long. So we will quickly just mention the declarations that Trinidad and Tobago has under the Madrid Protocol. Quickly go through the role that the TTIPO plays when they are the Office of Origin and when they are the designated contracting party. We'll look at some stats that we have at the Office for Trademark Applications, some of the initiatives by the TTIPO, and some of the public education initiatives that were done. And then we'll quickly go into the STLT treaty and its implementation in Trinidad. So the Madrid Protocol Treaty, its instruments to accession were deposited with WIPO's Director General in 2020, and in 2021, on January 12th, the treaty became in operation. These are the four declarations made by Trinidad: the extension of time refusal period being 18 months. When you're designated Trinidad and Tobago, we do require an individual fee. Wages of divided international registrations are not provided for, and that is because we don't have it presently under our national laws, so we do not have it and would not have it in our international laws. And lastly, you must state your intent to use the mark in Trinidad and Tobago. TTIPO, as an Office of Origin, has a few functions. Before the application leaves us, we have to certify the application, the international application that is, before it goes to WIPO. There is no handling fee that is required by the applicant when applying for the application. Filing language is in English. And our office uses the current NICE classification version, and that is the 11th edition. If needs be, you have to provide, or you are required to provide, a translation or a transliteration of your mark. As a designated contracting party, the TTIPO also has a few functions. Once the application reaches Trinidad and Tobago in our database, the office conducts a detailed search, not only of our database, but we conduct searches of varying sorts with respect to the application that is before us. And in Trinidad and Tobago, we examine both on absolute and relative grounds. If your application is successful through those stages, your application proceeds to publication in our online journal. And if your application has been successful through that stage of publication, 3 months after your application, once no oppositions have come into the office, so received by the office, your application is automatically registered then. So these are some statistics, as I mentioned, with trademark applications at the TTIPO. So these are statistics for the period of January 12, 2020 to June 12, 2020. As you can see, the significant portion of applications at the office were by non-resident applications, standing at 70%, and resident applications at 30%. In comparison to last year's period in 2021, keeping in mind that as of January 12, 2021, Trinidad and Tobago implemented the Madrid Protocol, meaning we would have received or started to receive applications this year through Madrid designations. So you can see that non-resident national applications took a drop, I would say, to 52% from 70% last year during the same period. There was an increase of 1%, but still an increase of resident applications at the TTIPO, and the balance standing at 17% were Madrid designations at our office. And with many thanks to WIPO and my controller, Mr. Ashgrally, and also the staff at the TTIPO, this year on June 28th, we had our first international filing by the agent for the CarIPI mark. That was indeed a long process, but a very exciting time for us at the office. So these are a few of the training initiatives that were done or that the TTIPO had. We had a study visit that was done to the Madrid registry by persons of the TTIPO. That was as far back as 2014. We had many national workshops that were done. There was a mission that was held at the TTIPO with our IT and trademark staff at the office. That was by Mr. Neil Wilson from WIPO. There were many IPAS missions that were held by Mr. Bush at the office. And in 2021, the first virtual desk audit was done in preparation for the implementation in January 12th, 2021. So these are a few public ed initiatives that we had for the Madrid Protocol. There was a workshop that was held on January 29th, 2021 with Expo TT. And it should be mentioned that Expo TT has a lot of financing facilities that are available for persons. And the link on my presentation, you will find all the information on their website with respect to the different details and how you can make your application. There was a 2-day workshop with the Sport TT, and there were 2 virtual webinars with Sport TT as well this year, recent being on April the 18th. Also, there are many what we call IP clinics, which are one-on-one sessions that are held with different stakeholder bodies, and these are some of our major stakeholder bodies, be it NEDCO, NIHUS, CARIPI, Planting Seeds, and of course our University of the West Indies. This is just quickly the establishment of our Madrid Protocol Processing Unit. It was established by Cabinet Note 1638, apologies, in 2014. And the unit consists of trademark system specialists who are mainly trademark examiners. There are administrative operations administrators and modification operations officer. Those mainly deal with modification applications. However, they do also do trademark examination. This is a quick screenshot of our website itself and where you can find all things Madrid, I would say. And you would be able to find all the links as well to all your forms, your fee calculators, etc. This is the booklet that we had that was mentioned before, that was done specifically for Trinidad and Tobago, and we would like to thank the EU IPO very much for assisting us in having this very detailed and very good booklet. This is also available on our website. So I'm quickly going to run into the STLT in Trinidad and Tobago. So we did deposit our insurance tax session for the STLT in 2019. Preceding that was our proclamation of our new Trademarks Act, which facilitated the implementation of it and allowed for electronic filing of trademark applications. Trinidad and Tobago was the 50th member of the TLT, And of course, as mentioned, I believe it was in WIPO's presentation, that it is a modern and a modern way of trademark registration procedures. This was also mentioned, so I will quickly say it gave us also in Trinidad and Tobago rights to allow applications such as non-traditional marks, 3D marks, sound marks, touch marks, and movement marks. This is just a quick screenshot at the point in time when Trinidad deposited its instruments that were also deposited and the Marrakesh Treaty. And so this gave the STLT allowed Trinidad and Tobago to have all their online facilities. So we have our entire online system that is fully operational. The electronic filing of industrial property applications through WIPO File. You can also file your other modification documents, such as your change of name and your change of address, your authorizations, etc. You can now make your online payments on our website via credit card, via the debit Visa card. And iPassport is not operational as yet in our office. However, we hope that in the near future, we can have that in operation in our system. That will definitely be a big plus for the office. WIPO Publish is also available at our office, and we are also hoping to have that available online soon. All correspondence can now be sent or received by the office electronically. And we also have our electronic journal and our electronic registers. This is just a few quick links to all the information that was mentioned before, our regulations, and all of these are on our website. And I would like to thank you. I hope I did not take too long. I think I almost stuck to the 10 minutes. Thank you, Mariana.
Thanks a lot to you, Steffi, and also to Corinne Flowers. You did stick to the time. Now we have a last item, which is the testimony from the private sector perspective. And I welcome to take the floor Ms. Rodette Page, Legal Counsel of ACB Caribbean, who will explain how this commercial bank has used Madrid's system to protect its trademark. Please, Ms. Page.
Thank you. Good day, everyone. Trust you can hear me well. Yes?
Yes.
So at the outset,
Yeah.
I would like to express my appreciation for having been asked to share ACB Caribbean's experience in applying for the international registration under the Madrid Protocol. I must admit I was a bit excited when Ernesto included reference to ACB Caribbean's new logo in his presentation. So as background, ACB Caribbean, we're currently one of the leading financial institutions operating in both Antigua and Barbuda and now in Grenada. We have been in operation since 1955, that's over 65 years now. And we are certainly committed to strict compliance with our regulatory requirements, good governance, and creating value for our stakeholders. We are actually a public company with over 5,000 shareholders. And currently I serve as the legal counsel corporate secretary for the institution, and I've been in this role for over 12 years. So recognizing that I am one of the last set of panelists, I wish to assure you that I will be brief, but trust that at the same time, I can provide some useful insight from our perspective on the entire process. Okay, so during this presentation, I will highlight just a few key features of our experience. The first one, we ensure that we were well informed about the process, the benefits and the costs in the first instance. We were already familiar with the importance of trademark registration and protection locally. So at the time, we were at the stage of rebranding as part of our a recent acquisition in the financial industry. And we would be moving from Antigua Commercial Bank to ACB Caribbean to reflect our expansion goals, not only in our local market, but also regionally. So In November 2020, as you see on the screen, when we submitted our local application for our new logo and tagline, we were encouraged by the local registry staff to consider applying for protection under the Madrid Protocol. So having received that encouragement, we started to conduct our own research on the matter. And as perfect timing would have it, we then became aware of a seminar hosted by WIPO in cooperation with Export TNT, that's a former presenter in respect of the Trinidad and Tobago Intellectual Property Office in January 2021. And so we participated in this seminar on the Madrid system, which basically improved our knowledge on the process. We also had, in terms of another feature of our experience, we also had significant local support from our trademark registry. Our local registry showed particular interest and encouraged and facilitated the application. These were marked by several follow-up telephone calls to offer assistance to start the process. In fact, there was so much interest, I became mildly suspicious as I could not recall having had such attention from the registry's office in my previous dealings with them. But in any event, I am happy to report that it was just genuine interest on their part to promote the additional facilities available for protection. In general, we found the online application process to be simple to navigate. After obtaining the local application number from our local registry, we were guided to the WIPO site and started the process. We took our time to ensure that the information was accurate. The form was simple to complete and troubleshooting was helpful. We encountered one main challenge in editing the application after it was completed, after we had been guided by the registry to include certain disclaimers. So we had an issue in terms of retrieving the application on the site. It was just not showing up in our account. However, eventually we were able to edit the form after a third attempt and the form was retrieved. We also found during the process that we had limited choices with respect to the number of Caribbean countries that were available to choose from. So for our first application, we only selected one country as a quote unquote test case on our end. Our intention is to expand this protection at a later date. And so finally, it is noteworthy that we are still in the midst of the process. We have paid our fees to our local office. We completed the online fee payment to WIPO, which was simple, noting that standard payment options were accepted. We have since received an email requesting a further edit to our application, which has since been addressed. And so we're nearly there. So overall, our verdict still remains outstanding, but so far, I must say that we are pleased that we made the decision to invest in additional protection in areas critical to our company's brand, and would certainly encourage other entities in the private sector to do the same. So as I started with a thank you, and I end similarly with a thank you. Thank you for your attention.
Now we move on with Mr. Nicolas Fouquet, Managing Director at Santos, France. Nicolas will explain how an SME like Santos has invented and produced in France and has managed to sell to more than 130 countries because of a good global IP strategy. Please, the floor is yours.
Hello. Hello from Europe. Hello from France. I own a very small family company here in Europe, and I will try to show you how we use IP, even if we are a very, very small company. Santos is a French manufacturer of food juice equipment, I would say citrus juicers and coffee grinders. I move to the next one. We make everything here in France, but we export worldwide. And today we export in more than 130 countries. What seems huge for a small company, but I will explain you our history. Everything is made here in France, in a small city in Lyon. We design everything here, we assemble everything here, but we are on a small niche market, which is B2B business, not for home use. That's why we can have such production in Europe and exporting worldwide. We are 50 people and 20 million euro turnover. That is to explain you the size of the company and how we use intellectual property. The company was created in 1954 by my grandfather to provide some of the first commercial electrical equipment for bars, restaurants, and hotels. That's a long, long family story, strong heritage. The worldwide trademark Santos is really a synonymous of reliable and sturdy products. And this brand, Santos, was already protected in 1988. So I showed here a few pictures of our history, and the old pictures shows a long, long history. So what are the products we make? We make citrus juices. And also I was happy you told about some coffee in Jamaica, because we make coffee grinders, and we love all these fruit juice, and we have a huge business, especially in juice bars, which are really popular here in Europe, using fruits from all over the world. This is our last product. It's a blender, a compact brushless blender with a specific motor. We are the only one to make such technology in the world. Of course, it's professional. You will not have it at home. And we sell it to big chains all over the world. So where do we sell? We have a huge market. We have some trade shows everywhere in the world to make this huge market. Most of the trade shows are in Milano, Shanghai. We sell a lot in China. It's a huge, huge market. We go to Singapore, to Hong Kong, and of course also in the USA, which is a huge market for juice bars, and also for coffee. Here are some pictures of the users, because we make professional equipment. Well, sometimes we are happy to make a direct connections with the people who are really happy to use our products all over the world. So here we come slowly to IP, because in fact we are a small company, but we work with very, very big chains like Jamba Juice in the USA. And I can tell you, when you sell your products to such big companies, you have to be protected, because your brand becomes famous everywhere, and you have to be strong even if you are a small family business. So that's my link to IP strategy. The history of IP is a complementary of a generation, because in the 60s, my grandfather wanted to protect the technical parts, the inventions, the technical patents. And then later, my father decided to protect the brand, because Santos was becoming a very famous brand. So we had to protect the brand everywhere in the world. And after that, with my brother Aurélien, that's the last picture, we tried to redesign nicer looking products, and then the design patents were really, really important. That's the history of how we handle IP. So we use the 3 types of IP protection: the technical patents, the design patents, and also the trademark patents. So we put a lot of money in R&D. That's why we want to protect the products with the IP. And we think that if someone wants to make a juicer, at least it will be different than ours, because we have a design patent. The IP strategy is to cover the main region of the world, and we try to have a global covering, especially on future-oriented markets. So here we come to the international treaties, because you know, the words of Madrid Treaty or The Hague Treaty is something I discovered years after years, because the main idea for us was to cover our markets. And these treaties help us to do it very simply. So we protect the products, then we can develop the sales worldwide. Here is the protection we used for the blender number 66, the brand new one. And the cost of protection for the design was only 1,000 euro, which is quite easy even for a very small company. Here are some older patents. I say patents, but this is a design patent. The juicer from 2002, another juicer in 2014. And all of these are covered because of the Hague system, which is worldwide protection for, almost worldwide protection for design. So that's the map of the Hague system that has been shown before. And it's really interesting for us because many new countries enter the system, and years after years, we see the system improving, and then we can cover the world market without too many new costs. Here is Madrid Union, the map that you have seen before for trademarks, and also it's a wide covering, and that's how we could cover the Santos name, which is a name that you say everywhere in the world the same way, and we could cover it almost in all our markets. So here is, we are very proud of this because when we go on the WIPO database and you type Santos, you see all the countries that we cover, and that makes us really strong, especially when we sell to big juice bar chains. We are unique. And also because of IP protection, we can communicate really easily. And that's how we can show the exploded view with all the spare parts and show very easily our product to the world because we are not afraid to be copied. So on our technical leaflet, you can see that we show the brand protection, the design protection, and we show also some technical patents that we use. And IP is good for dissuasion. Then Santos is a name now in all big juice bars, and all our competitors know that we are protected and they have to do different. Of course, in the past, we had very difficult times by people copying our products, and we had to fight. And if we had no IP, we couldn't have done this. And this strategy is protecting our factory, only 50 people, but it's also protecting our customers worldwide and also all our suppliers. So I was happy to tell you today about how a small company can use IP, and I really thank EU IPO for inviting me.
Thanks to you, Nicolas, for sharing this experience.
Thank you to all speakers. Thank you to Santos for spending his precious time here, as well as ACB Caribbean, the WIPO, WIPO Trinidad IP Office Belize. And thank you all attendees for staying with us.